नमस्ते सुनाओ, लेट्स क्राफ्ट आउट एन आंसर ऑन द राइट टू एजुकेशन. ऑलराइट, एंड राइट टू एजुकेशन पे जब भी जौन सा मर्जी प्रश्न आए आपके पास, you have to write this. So you have to start out your answer with right to education was not included in the list of fundamental rights, and it was only included as a DPSP under Article 45. So do mention that you know that originally it was not a fundamental right, at least it was not included as an explicit fundamental right, and mention Article 45 to begin with. All right, and Article 45 only originally provided for education until the age of 14 years, and it aimed to provide this or fulfill this goal from 10 years from commencement of the constitution, that's 26 January 1950. Now therefore, ideally by 1960, primary education should have been made free, but only some, not all states signed up for this, and this is the very crucial factor that you have litigation around this right. कि भाई बताइए, why did you include or mention even, well, education even in 41, in 45, if you had just no intention of fulfilling it? All right, so the Supreme Court implied that the right to education flowed from 21, 24, 30 clause 1 etc. in various judgments. We are just going to see that. आपने दो जजमेंट तो जरूर ही मेंशन करनी है, दैट्स मोहिनी जैन और उन्नी कृष्णन. अभी हम देखते हैं कि इनमें हो क्या रहा है, बिकॉज द केसेस आर इंटर रिलेटेड. बाकी आप कुछ मेंशन करें ना करें, इवन इन अ शॉर्ट आंसर, लेट्स से 10 मार्क, ये दो जजमेंट हमेशा राइट टू एजुकेशन के साथ जुड़ी रहेंगी. 86th अमेंडमेंट मेंशन करनी ही करनी है, आरटी एक्ट 2009 मेंशन करनी ही करनी है. ऑलराइट, so in 1958, so the story is starting in 1958, and that's a reference Kerala Education Bill. Basically the schools in Kerala were primarily being run by minority institution, basically minorities only. So the minority run schools were barred from charging fee. It is not that only minority run schools, but primarily सारे school ही minorities run थे. So they were barred from charging fee from the students, but they did not, the state did not compensate them. भाई अब school चला रहे हैं तो school चलेगा कैसे? फीस के दम पे चलेगा. So state said you will not charge ahead, we will basically, इसका मतलब ये था कि we will provide it to you, but they never did. Alright, so we are now standing in court. So Supreme Court held that Article 45 does not require that obligation to be discharged at the expense of minority communities. So obligation of who? The state. It cannot be discharged at the expense of minority community. यहाँ से story चल रही है. Then must mention उन्नी कृष्णन. In fact, उन्नी कृष्णन से पहले भी आप मोहिनी जैन mention कर सकते हैं. अगर आप ये अभी नहीं लिखना चाहते तो बाद में आप लिख सकते हैं. Not to worry, it will get repeated. So in Unni Krishnan JP versus State of Andhra Pradesh, that's a 93 ka case law, that the Supreme Court held the right to education flowed from Article 21, and this was deduced, the right was being deduced from 41, 45 and 46. Articles 41, 45, 46. I wish to basically ask you to pause here and have a look at 41, 45, 46 from the Bare Act right now, and then resume and come back to the lecture. So a child has fundamental right to education up till the age of 14 years. ठीक है जी. यहाँ पे 41 के अंदर क्या है? राइट टू वर्क, टू एजुकेशन. वाह, तो राइट टू एजुकेशन ओरिजिनली तो यहाँ पे दे दिया और 45 में दे दिया, तो फिर फंडामेंटल राइट कैसे? पार्ट 4 आर्टिकल 37. इट्स नॉट जस्टिशिएबल, राइट? So court relied upon 41 to illustrate that the right, basically the right was flowing from 21, but the Supreme Court warned that you will not apply this logic to ये आपके कि other rights कि आपने सारे rights ही flow out करा दिए, जो DPSP में mentioned है सारे के सारे 21 के through ही flow out करा दिए, आप ऐसा नहीं करेंगे. ये this is primarily, this logic is being restrained to article ये आपका जो the right to education. So this case and can't follow similar approach for other DPSPs for rights to get declared under 21. So this is right to education is a special case. So Article 45 was also construed by the court as supplementary to Article 24. Pause the lecture here, check what Article 24 is saying. Is it talking about prohibition of children, right? Well, basically up till a certain age, which is mostly 14. So the word life, the Supreme Court said, it includes education and it promotes dignified life. It actually said this in Mohini Jain. अब हम आ रहे. So Mohini Jain के अंदर यहाँ पे this the question of the right to education being a fundamental right for the first time. It arose in Mohini Jain versus State of Karnataka 1992, one case law prior to Unni Krishnan. ठीक है जी. तो यहाँ पे क्या हुआ था, कहानी थोड़ी सी अपने आंसर में एक्सप्लेन आउट जरूर करके आइएगा कि कर्नाटका लेजिस्लेचर वांटेड टू एलिमिनेट द कैपिटेशन फी. What is a capitation fee? Basically capitation fee is all about आपकी जो admission के time पे जो institute से आपसे लेते हैं ना कि जरा इधर आना, ये 2 लाख रुपए मेरी जेब में, right? So that is capitation fee. So the Karnataka legislature wanted to eliminate this, so it regulated tuition fee as well by one notification and said कि जो आपकी जो हमारे जो colleges हैं उन पे जो गवर्नमेंट सीट्स हैं उनमें 2,000 रुपये की फीस लगेगी. अदर स्टूडेंट्स और नॉर्मल अदर सीट्स बेसिकली डिवाइडेड द सीट्स कि उन पे 25,000 फीस लगेगी एंड 60,000 फी लगेगी फ्रॉम स्टूडेंट फ्रॉम आउटसाइड स्टेट. आई बिलीव इफ आई एम नॉट मिस्टेकन दिस इज प्राइमरली फॉर मेडिकल कॉलेजेस. ये वाली जो स्कीम थी, बट आई कुड बी मिस्टेकन. एनी विच वे 2,000, 25,000, 60,000. ठीक है जी. So writ filed by a student who's from outside state and the Supreme Court quashed this notification कि ये क्या बकवास है. This is absolutely arbitrary and violative of Article 14, right? Right to equality. How can the state do this? How can the state be charging this? So court, well, it said that 21, Article 21, that's right to life. अभी 86 amendment नहीं आई हुई है. Article 21, right to life, read with 38, 39A, 41, 45 implies that right to education is a fundamental right. ठीक है जी. So for the first time in Mohini Jain versus State of Karnataka. That's also one MCQ sort of a question that they keep asking. So because without, well, making the, now this is important, write it down word to word. Because without making the right to education under Article 41 a reality, right to education 41 के अंदर दे रखा है, as I've showed you, without making that as an explicit fundamental right a reality, fundamental rights generally speaking in part 3 would remain out of a reach of majority population which is illiterate. So for example, without education, how exactly do you really get to know about that you have a right under Article 19, you can express yourself freely, there is freedom to basically speech and expression. How do you do all of this without the right to education? ठीक है जी. And यहाँ पे Supreme Court labeled private institutions who were charging an exorbitantly high fee as teaching shops. कि यू कैन नॉट, मतलब कैपिटेशन फी आप नहीं लेंगे. अब मुसीबत ये आ गई. अच्छा चलिए मुसीबत पे ज़रा थोड़ा आने से पहले जस्ट एक बार देखते हैं. सो कैपिटेशन फी वायलेट्स आर्टिकल 14 एंड कोर्ट हेल्ड दैट द स्टेट शुड प्रोवाइड एजुकेशन फॉर ऑल एट ऑल लेवल्स. स्टेट का काम है स्टेट करे, राइट. अब ये तो जजमेंट सुप्रीम कोर्ट ने बहुत ज़्यादा वाइड कर दी, तो दिक्कत हो गई. सो क्वेश्चन अरोज दैट शुड प्राइवेट एजुकेशन प्रोवाइडर्स शुड दे शट डाउन. I mean, should they really shut down कि भाई ठीक है फिर हम बंद हो जाते हैं ना जब स्टेट नहीं करना है. Why are private educators, for example, such as me, are standing here, right? So should they shut down? So this was a 2-judge bench in Mohini Jain, and question came up for consideration in Unni Krishnan. Basically, again this question कि should private वाले कहाँ जाएं? So this was a 5-judge bench. So this was a follow-up to the Mohini Jain case, you can say. So यहाँ पे the Supreme Court said that every citizen has right to education till 14 years and beyond that, write this down, it's limits of the economic capacity and development of the state. So up till 14 years, state is under an obligation, it's compulsory that the state is going to provide you with the education. But beyond that, state to provide you education, it depends on the limits of the economic capacity and development of the state. of state पिछड़ा ही इतना, आपको क्या ही एजुकेशन देगा? हॉस्पिटल बनाएगा, सड़क बनाएगा, एजुकेशन देगा. समझ रहे हैं बात को? ठीक है जी. So 41, 45, 46 basically to discharge these obligations under which basically the state has under 41, 45, 46, the private institutions are necessary but commercialization of educations cannot be permitted and higher fees वो ले लें but capitation ना लें. बेसिकली ऐसा एक ब्रॉडली इन्होंने गाइडलाइन इशू करी एंड कोर्ट इवॉल्व्ड अ स्कीम कि जी कैसे आप क्या काम करेंगे. वी आर नॉट गोना गेट इनटू दैट स्कीम बट डू मेंशन इन योर आंसर बट इट वाज हेल्ड टू बी एन अनरीजनेबल रिस्ट्रिक्शन अंडर 19 क्लॉज 6 इन टीएमए पाई फाउंडेशन वर्सेस स्टेट ऑफ कर्नाटका. दैट्स अ 2002 का केस लॉ कि ये जो आपने जो स्कीम इवॉल्व करी उन्नी कृष्णन के अंदर की ये वाले प्राइवेट एजुकेशन वाले ये करेंगे वो करेंगे. This was found to be violative of their fundamental right, that's 19(1)(g) में to their anyone can practice their profession, and it was held to be an unreasonable restriction. So the scheme was reformulated in TMA Pi Foundation. And so the government, was overlooking all of these developments. So they came up with the 86th Amendment, which introduced 21A in Part 3 of the Constitution, making the right to education a fundamental right. The state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. So there has to be a law. So state will pass a law, but they never really passed it like immediately. they passed in 2009. So 2002 में 86th amendment came in. It made RT an explicit fundamental right under part 3. अच्छा, इससे पहले भी fundamental right वो declare हो चुका था, कहाँ पे? मोहिनी जैन के अंदर. But यहाँ पे अब हमने confusion ही हटा दी. The amendment also added clause K to 51A. Article 45 was also amended. Till 6 years हमने काम कर दिया. And in some case laws, you need not quote the judgment. 21A has been described as the most important fundamental right. And another connected amendment with this is the 93rd amendment, which introduced the 5th clause in Article 15. The RTE Act 2009 was enacted later in 2009, and in which state has to provide, one of the key features of the act is that state has to provide a neighborhood school to every child till basically at the age of 6 years, not till, at when they reach the age of 6 years, you have to provide a neighborhood school, all right. And no capitation fee or screening of the child or the parent will be done in these schools. The admission is compulsory because, well, right to education is their fundamental right from 6 to 14 years. ठीक है जी, तो clause K add कर दिया गया, article 45, article 21A. So all necessary elements. Mohini Jain, Unni Krishnan, दो case laws, TMA Pi Foundation, तीसरा case law, 93rd Amendment, 86th Amendment, RT Act 2009, Article 21A, and flowing out from 41, 45, 46. जैसे ही mention कर देंगे, and originally that this was not a part of, basically this was not a explicit fundamental right when we began with our constitution. Still, our answer covers out all the details. All right, wishing you all the best. See you in the next lecture. Take care.